On today's segment of the Legal Minute, should I buy a franchise, and what exactly is involved in that? Simply put, a franchise is purchasing a turnkey business opportunity. You're buying all of the intellectual property rights to that business, as well as training and support and their assistance in getting you, the owner of the business, open and operating. Generally, you pay an upfront fee called a franchise fee for buying into the business franchise. You may also pay additional fees, such as support fees or training fees, point of sale and merchant fees, and other types of fees. Normally, there's also something called a royalty, and it's a percentage of your gross revenue that's also paid to the franchisor each month. Besides all the fees that we've discussed so far, you also need to make sure that you have sufficient capital to meet initial inventory and ongoing inventory expenses, working capital, and other costs of doing business that are not part of the franchise. So why buy a franchise? According to the International Franchise Association, 90% of new businesses will be out of business within 5 years, but 90% of franchise businesses will still be in business in 5 years. When you buy a franchise, you're buying a proven successful model. It's the reason why they're so successful. When you purchase a McDonald's, you know that when you get into it, you're likely going to make substantial money. Regulated by the Federal Trade Commission, franchises must provide you a document called a Franchise Disclosure Document, or FDD. This is a 23-item document that explains everything you could possibly want to know about that business. From who owns it and who the operations officers are, to the types of training they provide, the sort of content of the operations manuals, who your competition is, and how the business generally works. That may also provide financial performance information and audited financial statements for the franchisor. It's important that you do not, under any circumstances, sign a contract or provide any funds to any franchisor until after 14 days of your receipt of that franchise disclosure document. Perhaps most importantly, you must read and understand everything that's in the franchise disclosure document. If you don't understand it, don't sign the agreement. The document itself, besides the 32-item franchise disclosure document, contains many attachments, including the actual contract or standard franchise agreement that you're going to be signing, as well as additional addendums for things such as merchant services or point-of-sale systems that you're going to have to lease, non-competes, non-disclosures, and all other types of agreements that are required to be entered into as part of the franchise. Should you have questions about any of this, do not sign the documentation until you're confident you know exactly what it says. Franchise laws vary widely from state to state, despite the fact that franchises are federally regulated. Just because the Federal Trade Commission is responsible for the franchising industry does not mean that they've actually read or approved that franchise disclosure document. You should contact an attorney licensed in your state, as well as a CPA, to make sure that you understand the risks and consequences of buying into this particular business that you're looking at. If you have any questions or comments about today's subject, feel free to visit our website, www.nevadalawgroup.com. This has been the Legal Minute.